Good morning. I'm Larissa Draves, and I'm with the Senior Enrichment Day Planning Committee. Welcome to today's webinar. While we wish we could be in person today, we had to make a decision about what to do as Senior Enrichment Day several months ago, while we were not able to gather in person. So as disappointed as we are that we're not in person today, we're thankful for our technology that we have. We might have a hiccup or two on this because I'm new to this format and I'm learning, so please bear with us, but we're all working as volunteers this year, and we appreciate your patience, and we are excited about being able to do this. And then the videos will be housed, the recording will be on the Senior Enrichment Day website, which is www.seniorenrichmentday.com. During the presentation, if you have any questions, I think we'll go ahead and just use our chat feature. Most people are familiar with that. If you've been on any kind of technology, just go ahead and put your questions in the chat so that Todd can answer that along the way. So I'm going to introduce Todd at this time, and while I do that, he can get his PowerPoint set up. Todd Balkema, thank you so much for joining us. Todd received his Bachelor of Science degree from Western Michigan University, majoring in political science and economics. He received his Juris Doctorate degree from Thomas Cooley's Law School in Lansing, Michigan, and is a member of numerous professional organizations, including the National Academy of Elder Law Attorneys. He's also a board member with the Fremont Foundation. His practice concentration is in the area of elder law, with an emphasis in medical planning, special needs, probate, and trust administration. He currently resides in Big Rapids with his wife and his son. Before we get started, Todd, I want to take one more minute and thank our sponsors. I forgot to do that earlier. So thank you to Spectrum Health Big Rapids for being our advertising sponsor today. Thank you to Lerner, Zerny, and Fath Financial Group for the use of their conference space. I'm in their beautiful space now, and you'll see some artworks behind me. And also thank you to the Mecosta County Commission on Aging for keeping Senior Enrichment Day part of our community for the last 30 years. So thank you again, Todd. I'm going to mute myself and you can get started. Thanks so much.
Well, Larissa, thank you so much. Again, my name is Todd Balkema. I am an attorney with the Jordan Balkema Elder Law Center here in Big Rapids. This is kind of a unique format for me. I'm used to speaking in front of all of you. And I'm used to getting feedback from all of you at the same time. So you'll have to bear with me as we go through. I am also learning as we go. This is my first online seminar. So in here today's seminar, we're going to talk about estate planning. And the key word for us in our office is planning. And we always state that if failing to plan is planning to fail. Because with an estate plan, the whole idea is to begin a planning process with your documents and how you wish your life to proceed, and how after you've passed away, how you wish everything that you own to be distributed and who's going to be in charge. And that takes a little bit of planning. Now, we're all used to planning. We love planning for things that are important to us, like weddings and vacations and times with the grandchildren. You know, finally we're released from, COVID and confinement for the past 14 months. And now we can spend time with our families, go up north. We got to grab the flip-flops, sunscreen, bathing suits, make sure that the kids are arriving, make sure when the grandkids are arriving. And if we're going anywhere else, do we have our passports? Do we have our rental car, taken care of? Do we have our hotel room booked? We're all planning for all of that. We're all communicating with our family. We're all communicating with others in order to establish the plan. But there are other aspects of our life that we also need to plan for. And some things we need to start thinking about in developing a plan is a power of attorney, probate. What's the difference between probate and avoiding probate with a trust? What's the difference between a will or a trust? What about a patient advocate? What is that? Maybe we are eligible for veterans benefits, or we're not sure if we're eligible for veterans benefits, and we need to start looking into veterans benefits, need to start planning. Maybe there's some long-term care concerns for us in the future. Maybe we have Alzheimer's and dementia in the family, or we've been initially diagnosed with those diseases, or maybe we have Parkinson's. And we need to start, considering about our incapacity and planning for, future events. And then also, planning for when we're no longer with us. How we wish everything to go after we've passed away. Here again, that's planning. We're trying to, think ahead and have our wishes, incorporated into developing a plan for us. Now, you don't have to plan. You can choose to do nothing. Like my favorite slide here, Mr. Ostrid sticking their head in the sand saying, I'm not going to do anything. Doing nothing is still a choice, and it's still a plan. You've planned to do nothing, and you're just going to, enjoy life and let life, ride, and we'll see what happens. Now, I've told you in the past, for any of you who attended my seminars, I have been after my dad now going into my 8th year to get his estate plan done. And I'm only an estate planning attorney, elder law attorney. But again, I am just the child, and I'm still encouraging my father to do a little planning. Okay. So I do understand some of those who don't wish to plan. My encouragement to my clients are, if you plan, your voice is heard. That's what's key. Planning lets your voice be heard. What is an estate plan? I hear that a lot. What is an estate plan? I hear this mystical term, estate plan, and what does it mean? It's an estate plan is just the legal documents where, while you're living, you've laid out who manages your legal and financial affairs. If you become incapacitated, or if you can no longer make healthcare decisions for yourself, you've decided who's going to make those decisions for you, and you've decided, what decisions they should make on your behalf. In addition, there's other documents, and this is when you've passed away. And here we're thinking about, who will finalize your affairs? Who's going to wind up your affairs? And, how will your property be distributed? How do you wish everything you own to be passed on? Whether it's to your family, to charities. But here, the planning process is you just start thinking about, where you would like what you own, how it's going to be distributed. Okay. Key question: who needs an estate plan? I've heard this a few times in my office. I don't need an estate plan. We always view an estate plan in our office with this simple slide. I have a family here. I have grandma and grandfather. I've got 5 kids. I've got grandchildren. And out of these people, who needs an estate plan? Follow the arrows. All the adults need an estate plan. Everyone over the age of 18 should have an estate plan in place. The estate plan is going to let everyone know how they wish their life to be lived if they become incapacitated, who's going to manage their medical on their behalf, who's going to manage their legal and financial. It's also going to let them know how they wish their documents, to be distributed, how they wish their real property be distributed. For parents with minor children, it's also going to say, who's going to be in charge of my children? Who's going to be the guardian of my children if I'm no longer here? So we all need an estate plan, somebody who could act for us if we are unable to act for ourselves. What documents do I need? And here, I think we can break up the documents into 2 different forms. One is living documents, and the second one would be post-death documents. So we're going to begin with living documents. So while you're living, there are 2 main documents we want to make sure everybody has. One is a durable power of attorney for finance and real property, and one is a healthcare power of attorney patient advocate designation. Okay? Power of attorney. The power of attorney is the document that's going to let you designate somebody to act on your behalf if you are unable to manage your own affairs. So as an example, you have a doctor who's determined that you're an incapacitated person, you can no longer manage your affairs. Your power of attorney now has stated, this is the individual who's going to manage my bank accounts, manage my real property, pay my bills, talk to my pension plan on my behalf. Okay? The key with this agent is you need to select the proper agent. And the proper agent here is the one person you have faith in that is going to, one, follow your wishes, two, act in your best interest, and three, knows how to manage financial assets and real property. Some of my agents automatically pick their oldest child, and sometimes that is the proper person to select. Sometimes the agent is not the proper person to select. The oldest child may be the one who does not manage money well. Okay? Here we need to give concern and thought, who's the proper person? And not worry about if I'm going to offend my child if I pick number 3 instead of number 1. Okay? We just need to explain to them why we've made that choice. Additionally, we need to lay out what decisions our agent can make or can't make. I generally recommend that a power of attorney should be very broad with the authority that we're granting an individual. And the reason for that is Michigan law says that if we did not grant a power of an authority in a power of attorney document, you didn't mean for that agent to have that authority. And if a situation arises where we needed that specific authority that you didn't grant them, we have to go to probate court and ask the judge to grant us the authority to manage that aspect. Prime example, some of these downloadable forms that I've seen off the internet, people will download these forms, sign them, mom, dad become incapacitated, they'll bring them then to our office, and all suddenly that form says you cannot manage life insurance. Well, we may need to surrender that life insurance policy. Since that power of attorney restricts how we can manage life insurance, we've now had to go to probate court on numerous occasions in order to surrender or change the ownership on certain policies. I recommend that power of attorneys are generally broad with the authority that you grant. Okay? In Michigan, a power of attorney is effective 2 different ways. One is immediate. When you put pen to paper, that individual can automatically act for you. The second time a power of attorney is effective is springing in nature. And springing here means it springs to life. And it springs to life when 2 physicians have determined that you lack the capacity to manage your financial affairs. Once we have those 2 statements, that power of attorney then springs to life and your agent then can act for you on your behalf. Now, I've been using the word just power of attorney. Understand the key is durable power of attorney. Durable means it survives your incapacity. Generally, majority of the power of attorneys out there are durable power of attorneys. Occasionally, I will run into a power of attorney that just says power of attorney, right? And makes no reference to durable, that it will survive after incapacity. If the document doesn't state in there that it survives after an individual's incapacity, that power of attorney ceases to exist, has no authority once the individual's been determined to be incapacitated by a physician. Now, the other living document is your healthcare power of attorney, patient advocate designation. This is the form where if you go to the hospital, the social worker is sliding it to you just about every time you go in there. I have one client who has 7 different healthcare power of attorneys at the hospital, and we've had to call over to the hospital and say, hey, you have 7 different healthcare power of attorneys on file. I am so thankful they do it though. Here, that healthcare power of attorney is going to let you decide who manages your healthcare on your behalf. A healthcare power of attorney lets you designate an individual who can manage your healthcare or mental health, if it's in there, okay, when you've been deemed incapacitated by 2 physicians. or a physician and a psychologist. Understand, a healthcare power of attorney in Michigan is only springing in nature, which means you have to have that determination by two physicians or one physician and one psychologist that you can no longer manage your medical affairs. And then the healthcare power of attorney springs to life. And whoever you've nominated in your healthcare power of attorney to be your patient advocate is the person who can manage your healthcare decisions for you. Okay. They then now have the authority to manage your healthcare. Okay. Make decisions regarding end of life. Now they have to follow what you've laid out in your document. Because generally in your document, you're going to give them some guidelines. You're going to say, hey, if I reach this point, I do not want life-sustaining treatment, okay? Or I do not want, hydration or food, or I do not want. Here you're letting that patient advocate know what you want, because your wishes are the most important, okay, direction for us at this point in time, okay? Now, as an example, here I have Art and Sheila. Art and Sheila, happy-go-lucky, wonderful couple. They're enjoying life, okay? They don't need to worry about anything. They do not have a care in the world. I suppose I could have listed them out as, Richard and Lynn, Richard being my father, okay? Very happy-go-lucky, very enjoying life right now. Now we have an event. In an event in our offices, a situation in which an individual now is in the hospital. And in this case, we're going to say Art had a stroke. So here's my event. Art had a stroke and he's been transported to the hospital. Art has been determined to be incapacitated. He can no longer make medical decisions or financial decisions for himself. We get a phone call from Sheila. Sheila says, Todd, Art just had a stroke. I'm at the hospital now. They won't let me make medical decisions on his behalf. I'm really concerned. I'm worried about how I'm going to pay the bill. I know there's other bills that are coming in. Todd, we generally moved a lot of our money into this one account that just has Art's name on it. And Art paid all the bills. I didn't worry about paying all the bills. I just made sure, Art told me money was transferred into this one checking account that he paid all the bills. So I didn't have to worry about it. Well, I just went to the bank and the bank says, I'm not on the account. I have no check writing authority. I have no right to manage the account. I can't withdraw my own money that we transferred into that account. I don't know what to do. Well, Art and Sheila were really happy-go-lucky. They didn't plan. They didn't plan for an event or a possible event in the future. So they don't have a healthcare power of attorney. They don't have a power of attorney in place. For individuals where this arises, what happens next? What happens if I have an event and I have a stroke and I'm now in the hospital and my loved ones need to take care of matters on my behalf? Now what happens? We go to probate court. Probate court is the court that governs an incapacitated individual. So if we have an individual who's been determined to be incapacitated, okay, we can now go to probate court, okay, and we can have a guardian appointed for that individual. So a guardian manages the medical decisions for an incapacitated person. Okay, so we're going to go back to Art and Sheila. Art does not have a healthcare power of attorney that lets somebody act for him on his medical decisions. So now Sheila is going to go to court and have her self-appointed guardian, so she can now make medical decisions on behalf of Art. Likewise, Art does not have a power of attorney, so Sheila cannot make legal or financial decisions on behalf of Art. So we're going to petition, we're going to go to court and ask the judge to appoint Sheila his conservator. Conservator manages the legal and financial affairs for an incapacitated person. Now, a conservator does have to file an inventory with the court of all assets owned by the individuals incapacitated or is joint between that individual and another. That conservator also must do an annual accounting that lists out, this is all the income that's come in, these are the expenses that have been paid, and these are the assets that are left. All of those documents are public documents. In addition, for an incapacitated person that we have a conservator for, or a guardian, the probate court controls the property. We have to ask permission of the probate court if we're going to lease, sell, mortgage the property. So going back to Art and Sheila, they do not have a power of attorney. So Sheila cannot act on behalf of Art. So if we need to sell the house, Sheila has no authority to sign Art's name. And even if she's conservator, we still have to go back to the probate court and ask the court's permission to sell the family home. Okay, so please keep that in mind. There's a reason why we really want to have these documents in place, these living documents. It's going to help our loved ones take care of us later on. Now, we've been talking about living documents. We're now going to talk about documents when we've passed away. Okay, and I've listed some different plans out here. We have a will, we have a trust. Maybe we have to do planning for a second marriage. Maybe we need to do planning for special needs children or children or grandchildren who are receiving governmental benefits. So we're going to start with a will, okay? So typically with a will plan, you have your will, you have your power of attorney, you have your patient advocate agreement, and look at the bottom, folks. It says no joint property with children. Okay. Now, like in years past, I need to step on my soapbox and talk about joint property, right? I am in my office. We are not in favor of joint property with the children. Things become complicated with joint property. Now I know, I've heard it all. Clients coming in or prospective clients coming in and said, we've made property joint with our kids. Our mom and dad did it. It was really easy. Mom and dad passed away. We didn't have anything to worry about. Well, the advantages of joint property are we're going to avoid probate at death. Okay? So that's our advantage. So if we set up joint property with our children, we're going to avoid probate court when both of you have passed or one of you has passed away. Here are some of the disadvantages of having joint property with your children. Parents lose control of the assets. You no longer have sole control over your property or your assets. You share that control with whomever, like we'll say the children right now, who own the property with you. You need consent of children to sell, lease, or mortgage your property. How does that sound? You own real property and you wish to sell it. And let's say it's the 40 acres of hunting property we've had up north, or it's the cottage up north, and it's been in your name. You've owned it for the past 30 years, but now you want to sell it because there's other things you'd like to do, but you've added your children onto the property and they say no. We're sorry, we enjoy the cottage. We enjoy hunting on the 40 acres. We're not going to let you sell. They have a right to do that because they're a co-owner of the property. Divorce of children. You've made your property joint with your children, and now your future ex-daughter-in-law or son-in-law may have ownership rights to that property. You may lose part of those assets. Creditors of children. Your children's creditors can come looking for satisfaction, especially if they've gone bankrupt, in order to pay off their debt out of your assets that you've made joint with your children. Unintended beneficiaries. This is one of my big concerns. as an example, I'm going to go back to Art and Sheila. So I have Art and Sheila, they have 2 children, okay, a son and a daughter. And Art and Sheila's estate plan says when both of us pass away, everything gets divided equally between their children. And if one of their children are deceased, that child's share goes to the deceased child's children. Well, I have joint property. Art passes away. So the property is owned between Sheila and the 2 children, the son and the daughter. Son passes away. So now it's owned between Sheila and the daughter. Sheila passes away. Who owns the property? The daughter. We've inadvertently disinherited the son's children. Everything by operation of law goes to the daughter, and it's up to the daughter whether she wishes to share the property or not. Also, you may be disqualified for Medicaid benefits if you've transferred these assets within 5 years of requiring long-term care Medicaid benefits. So if Art needs to go to the nursing home and they've added their son and daughter to their home within 5 years, Medicaid is going to penalize them for making that gift. The gift is adding the children as co-owners of the property. Additionally, you may be disqualified for veterans benefits. The VA now has a 3-year look-back period. They're going to ask you, have you given any of your assets away over the past 3 years? And we're going to penalize you for giving away your assets. Based on the equation, the VA penalty can actually be longer than the Medicaid penalty. So we need to be very careful about adding our children to our assets. Oh my, okay, I'm gone. Okay. Probate, here with a will plan, a will is only effective in probate court. I've been asked this question a lot. They've said, hey, I have a will, I'm going to avoid probate. No, a will only governs assets that are in your name only, okay? And when you pass away, assets that are entitled in just your name are subject to probate court. A will is only effective in probate court, okay? So keep that in mind. So if you're concerned about probate court, maybe just a will plan may not be the best course of action for you. Another type of plan is a trust plan. A trust plan is just a way for us to transfer your assets outside of probate court, okay, without you giving up any control. Here, you've set up a trust, and a trust is just like kind of viewed as a holding account. And you've put your property into the trust, you've put your bank accounts into the trust, but you still control the trust. You can still sell your property, you can still, buy, transfer, make gifts of your property if you wish, okay? But everything that's in the trust when you pass away is going to avoid probate court. You have total control of those assets after death. It can be less expensive in administering after you passed away. Additionally, it's non-public, which means unlike probate court, where we file the documents where everybody knows all the beneficiaries' names in probate court, they know all their addresses, and they know all the assets you're going to receive. Here with a trust, it's not public. Nobody's going to know who all the beneficiaries are. Nobody's going to know the assets that are contained within the trust except for the beneficiaries. Another concern some of my clients have is with second marriages. So in this example, I have Lee and Sonia. Okay, they each have their own family, and now they've gotten married. Lee has 2 children, 4 grandchildren. He has some investments. Okay, Sonia has 3 children, 3 grandchildren, a cottage, and some investments, and she owns her home jointly. Now, they both, though, want to make sure each of them is cared for during a lifetime, but they want their assets that they've brought into the marriage to go to their children. So Lee wants his assets to go to his children when both Lee and Sonia have passed away. And Sonia wants her assets that she brought to the marriage to go to her children when both Lee and Sonia have passed away. So in this case, what we do is we actually are going to set up two separate plans, okay? Lee's plan says all assets for Sonia are going to be held in trust while Sonia is living. Same thing for Sonia. She says in her plan, I want all assets for Lee left in trust while he's living. Then both plans say, Lee's plan says when Sonia passes away, his assets go to his children. Sonia's plan says when Lee passes away, his assets are going to go to, or I'm sorry, her assets are going to go to her children. So when we're looking at, the assets, okay, for Lee and Sonia, well, first off, they own a home jointly. So those are joint assets, and they've already decided those joint assets are going to go to the survivor, okay? So the home is owned jointly, it may be, and if it is, it goes to the survivor. Bank account, they may have a joint checking account that they both add money to, to pay bills on a monthly basis. And they've decided that bank account is going to go to the survivor also. But then they each have separate trust. And, like I mentioned, Lee's trust has his property in it. Sonia's trust has her property in it. Both trusts provide for, when they pass away, it's going to provide support to the other spouse. When the other spouse passes away, their assets are going to go to their children. Okay, so here with a two trust plan, a trust for Lee and a trust for Sonia, we have followed their wishes in order to make sure both spouses are cared for during both their lives. But when both spouses are deceased, their individual assets are going to go to their individual children. Now, there's another great concern that we should have when we're looking at estate planning and planning in general. And that's individuals with unique challenges, right? These are our grandchildren and our children who may be receiving governmental benefits. They may be receiving Medicaid. They may be receiving SSI or veterans benefits. And some of these benefits, okay, are income and asset eligibility determinant, which means that if we leave a person who's receiving Medicaid benefits, something in our estate plan outright, they may lose their benefits. So we need to make sure we provide some special care and how we're planning for these individuals. Okay, so here's my warning page for everyone and my unintended consequences for individuals who are receiving governmental benefits and we leave them money outright. One, the loss of the benefits. Okay. And that individual who's receiving governmental benefits may need those benefits to survive. Okay. Two, the family may lose control over the assets. Maybe the child or grandchild who's receiving the money outright lacks the capacity to manage the assets effectively. So maybe we need to provide them some additional structure in order to make sure those assets are used for themselves. Second off, the state may receive part of their inheritance to pay back some of the benefits that that child or grandchild has received. So we need to have great care when we're planning for a special needs child or a special needs grandchild. Okay. Here, if we plan ahead, and again, I'm going to go back to planning. Okay. All the way through here, we're talking about planning, but with special needs individuals especially, we want to make sure we plan for them. Here, if in your plan, you have a special needs grandchild or child, you can put inside of your will or trust a special needs trust for that child or grandchild. A special needs trust is an exempt asset for Medicaid eligibility. A special needs trust provides that the Medicaid recipient child or grandchild, okay, may be the beneficiary, but it's up to the trustee, who is generally the family, okay? Typically, we'll appoint a family member to be in charge of this trust, or we'll appoint them as a trust director who can then direct a trustee on how to care for this Medicaid individual. But whatever is in this trust is exempt from Medicaid eligibility. So we're going to preserve that grandchild or child's benefits, okay? The assets that are contained in the special needs trust can be used to supplement the care comfort of that child or grandchild, okay? The family still can control the assets or direct how the assets may be used in order to supplement that grandchild or child, okay? And also, when that grandchild or child passes away, you have chosen who the beneficiaries are underneath that trust. So what you've said is, I'm going to leave X amount of dollars in a special needs trust for grandchild one. When grandchild one passes away, I want all the assets that are remaining in grandchild one's special needs trust to go to these individuals, okay? And upon the passing of grandchild one, the assets then would be distributed to those beneficiaries. So with a special needs trust, we've preserved the Medicaid recipients' eligibility for governmental benefits. Okay, we've provided them a mechanism in order to have additional care and comfort, okay, without affecting their eligibility. The family still has control over how the assets are distributed and managed. And we've decided where the assets are going to go upon the passing of that child or grandchild. Okay, but the key word here is planning. All the way through, we need to plan. So again, the key word all the way through from power of attorneys, healthcare power of attorneys is planning, selecting the proper agent, and giving some thought here of what authority and what care you wish in your documents. Under your will or trust, okay? One, who is going to be your personal representative or trustee? Again, like your agent under a power of attorney, you want to select the right person, okay? The person you have faith in who's going to be able to manage your affairs effectively, okay? Also, you've made a decision under your will and trust how your assets are going to be distributed. You've decided, where your assets are going to go, how they're going to be distributed, who will receive them, and maybe when and how they will receive those assets. Depending on the beneficiary, there are ways to distribute the assets over time. Okay, so depending on the certain situation that you may have, creativity can help develop a plan that benefits you and your beneficiaries. So, any questions from everything that I've gone through today?
Todd, you gave us a lot of material. This was wonderful. I have a couple of questions, and then we'll continue to watch the chat to see if anyone listening today has questions as well. How about, I know you're busy, you've got 4 offices that you and your partners represent. So about how long does it take to get an appointment? Can I get in with you within 30 days, or how long does that take?
Generally, you could get in to see me within a couple weeks at the most. Okay, generally I'm about 2 weeks out. I do have another attorney in our office, the Big Rapids office, and that's Stephen Balkema. He is my son. He does also practice in estate planning and probate trust administration. Usually you can get in to see him also within about 2 weeks. Stephen also is the one who still, I like to say, has the fire in the belly and enjoys going to court. So he's the one you'll see for guardian conservatorship cases. We do have another attorney in our office, and that's Kelly Dexter. She is another elder law attorney. She is out of our Traverse City office. But depending on where you live, you can see us, no problem. Okay.
Great. And that kind of segues into one more question I had, Todd. Years ago, I was not selected to serve, but I was in I'll just say I almost got picked pool for probate court. So could you educate me and others on the call? I understood, I found out that the case took 4 or 5 days to settle. What takes so long in probate court cases? I mean, you've kind of given us some good tips on how to avoid it, but what
Okay.
are some of the things what makes that take so long? Why such a long process?
Here, there's some statutory processes that we have to follow. And I'm not talking about the case itself here. I'm just talking about the time period. From the date we open up a probate, an initial probate case, and an application is filed to open up the probate estate, we're looking anywhere from about 10 months to a year before we can close it out. Okay. Because within that time period, one, we have to publish notice to creditors. That notice period lasts for 4 months. Okay. So even though we're still administering part of the estate, there's no distributions that can be done while the creditors period is in existence. Okay. In addition, usually we need about a month before we publish in order to start gathering additional information regarding the inventory, because depending on the size of the estate, we may not need to publish at all. Winding up the affairs, here we still have to do a final accounting and a distribution. Now, it sounds like you were actually being called in to be a juror at a probate case, correct?
Yes.
Yeah, okay. All right. So a lot of times, and here the cases vary. It could be a trustee who committed some malfeasance, misappropriated some assets, or a personal representative who misappropriated assets, or the PR, the personal representative of the estate. We could be suing a beneficiary to reclaim assets. Okay. Some assets transfer outside of a probate estate. And just FYI, people think they can make assets joint and they pass that outside of a probate estate and nobody can ever lay claim to those assets again. That's not the case. Michigan law provides that if a probate estate is bankrupt and lacks sufficient assets to discharge, pay off the estate's debt, we can actually go after and seize assets that have transferred by joint ownership.
Okay. Todd, we have one final question in the chat, and then we are going to have to wrap up. The question is, how is the deed to a house handled when a spouse dies, when both owners die, and the person indicated the house is part of a trust?
Okay. So what happens to the home when both the settlers pass away? Settlers are the individuals who set up the trust. So they've passed away. The home would be distributed however is listed inside the trust document. So here, even though we're outside of probate court, with trust administration, we have to provide notice to beneficiaries. We have to mail the beneficiaries a copy of the trust document. Okay, they're entitled to the trust document to know what's in it, because they may need to defend their rights, and the only way to know that is with the trust document itself. The trust document itself is going to say what happens to that property. Is it to be sold? Is it to be gifted? Is it, are we going to hold on to it? Some of my clients hold on to certain property for, 10, 20, 30, 40 years, depending on if it's a special piece of property that's been passed down in the family. So it's the trust document itself. So I would recommend then, if they're a beneficiary or if they're an heir even, because technically we have to give notice to heirs. Sometimes children aren't in the trust and we still have to give them notice to request a copy of the trust document so they will know how it's to be distributed.
Great. Thank you, Todd.
Sure.
Again, we greatly appreciate your time and you sharing your professional skills with us. And thank you for the contact information in case anyone does want to connect with you directly. This will be recorded and will be uploaded to the website in just a couple days. The website again is www.seniorenrichmentday.com. We're going to end this webinar. I would invite everyone on the call to join our 11 a.m. session. You'll have to disconnect with this webinar and reconnect by going through our website. There's a link there. Jane Rozier is going to present on aging anxiety. Thank you again, Todd. Greatly appreciate your time.
Thank you so much. I enjoyed it.